Hello, my name is Mike Tessera and I prepared this video presentation entitled ACCC Cheat Sheet February 2024. And if you've been watching my YouTube station for a while, you know that I do these every month where I summarise everything that's been going on in relation to the ACCC in that particular month. So in this particular presentation, I'll be summarising what happened in February 2024. Now, a bit of background about myself. I'm a competition and consumer lawyer and I've been running my own practice, Tessera Legal Consulting, for the last 17 years, and I help companies, individuals with competition and consumer law matters. I also do some expert consultancy work for a variety of legal publishers on competition and consumer law, and I've recently been appointed as general member of the Consumer and Commercial Division of the New South Wales Civil Administrative Tribunal. So I'm very much looking forward to that particular role, get my hands on some genuine consumer law type complaints. Prior to that, I worked at the ACCC for 15 years in a variety of roles, including as Director of Enforcement and Director in charge of the Mergers and Assessment Branch. The outline is pretty similar to previous months. A couple of court cases, a couple of enforcement actions, a lot of merger activities, a lesser amount of activity in the other areas listed there. Now, the big case in February was the criminal sentencing decision against Bingo, Aussie Skips, and the two CEOs, Tartak and Rizakis. And this was a case that was filed by the CDPP against these various companies and individuals, and it related to a short-term cartel entered into by the two companies, and all the parties pleaded guilty immediately at the earliest opportunity, so the matter proceeded directly to sentencing. And the interesting thing about this particular case is it was a two-party cartel, but it's apparent that no immunities were granted to anybody. So there must have been some other source of information for the ACCC to commence investigation. And when you read the judgments, it's not really clear how they found out about it. One thing that's, I guess, a bit of background here is I've been involved a bit in this industry because I was appointed by the ACCC as the independent auditor of the Bingo divestiture of the Banks Meadows site. So when Bingo bought Dial a Dump, they had to sell an asset and required an independent audit just to oversee the business being sold and ensure that it was sold as a going concern. So that was my role, and I guess during this particular price fix I was conducting my own investigation in relation to the sale of it. So that was somewhat unusual. So just looking at the particular case, as I said, it was a short-term price fix, and it was entered into over a 5-day period in May 2019, and Tartak and Rizakis engaged in a series of communications in which they made arrangements in relation to both collection and processing services. Some interesting or important background to be aware of is that prior to 2019, a lot of waste was actually transported to Queensland and disposed of up there because there was no levy on the disposal of waste. But then in 2019, the Queensland government, I guess, wised up to the fact that all this New South Wales waste was being dumped in its backyard and introduced a levy. So that immediately made it uneconomic to transport it up there by truck and dispose of it. So that resulted in a price increase in New South Wales and Sydney particularly. So it seems that maybe the two parties used the inevitable price increase that arose from the introduction of the levy in Queensland as a cover for their price fixing arrangements. So in relation to collection services, Bingo agreed to maintain a price increase of 25% for all its customers, or 23% for what it described as its top tier customers, and for Aussie Skips to increase its prices by at least 20%. So that was in excess of the impact of the Queensland levy on prices. The second one involved processing services, and this was Bingo agreeing to maintain a price increase of at least $60 per tonne or $35 per cubic metre at its processing facilities, but only the ones that were located near Aussie Recycling's facility at Stratfield South. So one of Bingo's biggest processing facilities actually at Auburn, so it's quite nearby. And then Aussie Recycling was going to increase its prices at that one facility, Stratfield South, by at least $50 a tonne or $27.50 per cubic metre. So that was agreements, as you can can see the second one is fairly narrow in geographic terms. The first one was much broader. Now, it's important to understand the maximum penalties because the penalties that were imposed were quite different, at least as far as the companies were concerned. So, as you know, the way the penalties work, at least at this stage, was $10 million, 3 times the benefit, 10% of turnover. So for Bingo, the 10 million turnover wasn't available because the 10 million wasn't available because the turnover was higher than the threshold. So it reverted to the 10% of turnover number. So that meant it was looking at a maximum fine of $40 million. Aussie Skips and Aussie Recycling, which much smaller companies in terms of turnover, and as a result, the maximum for each of those companies was only $10 million. So effectively, the penalties that Aussie Skips and Aussie Recycling were looking at was half as large as the penalty which Bingo was looking at. In terms of the personal penalties, Tartak and Razakis were looking at the same maximum penalties, which is effectively a term of imprisonment not exceeding 10 years or a fine not exceeding $420,000 or both. Now, the charges against two companies were different, and that's sort of interesting aspect to it. And it might arise from the fact that there were two companies involved in Aussie Skips contravention. So Aussie Skips and Aussie Recycling were each charged with the offence of intentionally making an agreement in relation to collection services in contravention of 45 AF1 of the Competition and Consumer Act. And Mr. Razakis was charged with aiding and abetting the making of those two arrangements. So it was only charged for making arrangements, whereas, as you can see, Bingo was charged with intentionally making an arrangement in relation to processing and giving effect to that arrangement in relation to processing. And by the same token, Mr. Tartak was charged with two offences of aiding and abetting Bingo in making the agreement and giving effect to the agreement. So I think it's interesting that the different charges were framed here, even though it was a price fixing agreement where they agreed to do the same things. But the way it worked, very briefly, was that even though they were charged with different things, the other offences that they engaged in were noted by the court but not specifically charged. So it did have an impact on the judge's determination of the appropriate penalties. So the penalties imposed, Bingo was convicted and a penalty was imposed upon it of $30 million, which is $15 million for each charge. And Mr. Tartak was sentenced for two criminal cartel offences, 2 terms of imprisonment of 18 months but served concurrently over 2 years as an intensive correction order. So that means that he doesn't have to actually physically attend jail, but he does have a conviction against his name. And he was also ordered to do 400 hours of community service. He was fined $100,000 and banned from managing corporations for 5 years. This is a very significant penalty, like 2 terms of imprisonment, 18 months, is a very serious penalty for this particular conduct. And I guess the early guilty plea was the main reason he avoided actually going to jail and was able to serve it as an intensive correction order. In relation to Aussie Skip Bin and Aussie Skips Recycling, the conviction and penalty, at least the penalty was significantly lower than Bingo, and that's because, as I mentioned before, the maximum penalties were much lower for Aussie Skips due to its turnover. So as you can see, they were criminal penalty of $3.5 billion or $1.75 billion each. And Razakis was effectively sentenced for the same term of imprisonment as Tartak, 18 months to be served concurrently over 2 years, also by intensive corrections order, but 300 hours community service and $75,000 fine. That may reflect the fact that he wasn't the prime mover. It seems that Mr. Tartak set the ball rolling here, so that might explain the higher penalties in relation to community service and fines. And he was also banned from managing corporations for a period of 5 years. The next case involved Mazda, and this is a case where the ACCC took proceedings alleging false and misleading conduct and unconscionable conduct that were unsuccessful at first instance, went on appeal. The primary judge's decision was reaffirmed. So the penalty went back to the primary judge purely on misleading, deceptive conduct and false and misleading representations. And this all related to consumer guarantee rights. And the ACCC ran cases in relation to 9 consumers, but these are really representative of a much broader problem. There are a lot more consumers in this particular situation. The court found there were 49 separate false or misleading representations made to these 9 consumers about the various problems with their vehicles, which were serious and recurring. And these all occurred within 2 years of the consumer buying the motor vehicle. And the court found that Mazda ignored or rejected requests from the 9 consumers for a refund or replacement, and claimed that they only had to repair the vehicle multiple times, including major repairs such as replacing engines. And the court decided that the appropriate penalty was $11.5 million plus $82,000 in compensation to some of the consumers for their various losses, plus a further $3,000 in compensation per vehicle. I guess the main thing here is 11.5 million get achieved specific in general terms. I'm not too sure it will. It's a significant penalty, but I think the ACCC would have been hoping for a lot more, a lot higher penalty. Now, in terms of enforcement, there were 2 enforcement outcomes. The first was Grey E-commerce Group Limited, and this was an allegation that the company had made false and misleading representations about the descriptions of vehicles on its website, including about the make, model, features, or undisclosed obvious faults with the cars. And it's an interesting case because Grays seems to have been caught out, or maybe they self-reported, I'm not too sure, but they admitted to engaging in misleading, deceptive conduct and making false or misleading representations. So they've admitted their conduct, and the ACCC and Grays have gone to the court with an agreed penalty of $10 million. So it'll be up to the court to look at all the evidence and determine whether a $10 million penalty is appropriate. The second case is yet another enforcement action by the ACCC in relation to the horticulture code. It involved a company called Total Food Network, who was hit with 2 infringement notices to a total value of $27,500. And the 2 contraventions of the horticulture code alleged against this company are fairly fundamental, really, when you think about it. The ACCC alleged that the company had failed to enter horticultural produce agreements, which is sort of the basic agreement you have to have if you're going to participate in this market, and also failed to prepare its terms of trade and make them publicly available. So these are very basic breaches, and it's surprising the company wasn't aware of its obligations, particularly given that horticulture code's been around for a long time. And these breaches were picked up through the ACCC's annual compliance checks in relation to the horticulture code, which involves checking out various players' websites or just writing to them and asking for their documentation. In mergers, it was a very big month. I guess the big decision was the decision by the Australian Competition Tribunal to allow the ANZ Suncorp merger. And as you probably recollect, the ACCC opposed this merger on the basis they were not satisfied it was not going to substantially lessen competition. Well, the ACT formed a totally different view. They didn't believe it was going to substantially lessen competition in the 3 relevant markets. So the supply of home loans nationally, the small to medium enterprise banking market in Queensland, and the agriculture banking market in Queensland. Now that's interesting in the fact that they're not saying it's not going to lessen competition, they just don't believe it's going to substantially lessen competition. That's obviously the test under the section. And the fundamental consideration was they didn't believe that Suncorp was a very vigorous competitor in any of these particular markets. So ANZ buying them out wasn't going to have a very significant impact on overall competition. The tribunal found that many of the public benefits claimed by ANZ and Suncorp were either not public benefits or were not specific to the proposed acquisition, so they would get very little credit in terms of the balancing up of detriment and public benefits. But if there's virtually no detriment, it doesn't really matter that there's very little in terms of public benefit. The tribunal also found that detriments from the acquisition were uncertain and unlikely to outweigh the integration benefits. So really, it wasn't clear that the merger was going to reduce competition. So the integration benefits of putting the 2 businesses together were considered a public benefit, and they would outweigh any potential detriment that may arise from the merger. Now, the ACCC announced shortly after the tribunal's decision that they decided not to appeal the case to the federal court, which surprised me a bit. I thought they might have a go. The interesting thing here is that it's not necessarily over. The Treasurer still needs to approve the transaction, and his consideration of the matter isn't just purely on competition grounds. It could be on national interest grounds. So he could say no to the merger. It'd be a big call. I think there's a chance he might say no to it, but we've got to watch this space to see what he decides. A merger that came across in February was involving realestate.com.au, which proposed to acquire Dynamic Methods. And this is another merger which was not notified to the ACCC in the voluntary scheme. So the ACCC found out about it through some other means, maybe someone complained or maybe in the newspaper. So the ACCC started looking at it and formed the view that it raised a number of concerns. And it involved the market for the provision of digital real estate advertising services, and REA is a very big player in that particular market. So the ACCC was concerned that REA is expanding its existing ecosystem of products and services would solidify its strong position in that market and give it the ability and incentive to harm its competitors. So obviously Dynamic Methods was considered to be a significant player in that market, and if REA was able to buy it, it'd put REA in a much stronger position. And furthermore, they concluded that the REA group would have the ability to control access to and data from digital forms which are necessary to providing real estate related services. So there's a number of concerns with this merger. Obviously the ACCC will do some further investigation and decide whether to oppose the merger or let it through. Not sounding good, but for realestate.com.au. A merger that was signed off on was Monash IVF's acquisition of Fertility North Holdings. This was a very narrow merger in the sense that it only related to the provision of fertility services in Perth, as opposed to some of the earlier mergers which the ACCC opposed, which had a much broader scope. And here the ACCC didn't believe this merger was going to reduce competition, mainly because there were a number of other providers in the market that would exercise some competitive constraints. So Genea, Dora, Concert Fertility, Fertility Specialist for WA. And I guess the important thing here is ACCC sees various segments of the market. So they see a low cost segment and a full service segment. And I guess this market appeared to be in the low-cost segment of the market. So the fact that there was a new entrant to that particular market, Oasis Fertility, suggested that there was unlikely to be any change in competition in the market for the provision of low-cost IVF services offered in Perth. Another merger which was signed off was Westpac Banking Corporation acquisition of HealthPoint. And HealthPoint is a payment application which enables healthcare providers to process real-time private health insurance claims. And I think the one like I was familiar with before the merger was HiCaps. I've seen that one around the place. And that is clearly the leading provider in the market, and it's wholly owned and exclusive to NAB. So really this is a case where Westpac is a very small player in this particular market and is seeking to increase its role in the market by acquiring HealthPoint. So that's probably going to actually enhance competition in the market, have another big player participate in the market and providing NAB and HiCaps with stronger competition. So the ACCC concluded this acquisition was unlikely to substantial competition. There was also a report by the ACCC issued where it reviewed past merger decisions, and this is the second report it's issued. The first one was issued a couple of years ago, and it was very concerning, some of the findings, particularly the fact that the ACCC found that some of the information provided to it by mergers parties was just misleading or wrong, and I think they probably got a few of their merger decisions wrong as a result of the wrong information they were provided. This more recent analysis of merger decisions has also raised some concerns. The three mergers I looked at were ANZ Terminals acquisition of GrainCorp Liquid Terminals, AP Eagers Limited acquisition of Automotive Holdings Group and Bauer Media's acquisition of Pacific Magazines. And again, the ACCC found that a number of the predictions and assumptions which they made in their original review did not actually turn out as they expected. The question is whether that's due to the information provided to them by the merger parties, which was incorrect. I haven't read the report yet, so I don't really know. I might do a separate presentation on it. But the interesting observation was that they had concerns about the effectiveness of undertakings. So I think that's the AP Eagers merger where there was significant divestitures required, and question marks over whether these undertakings were effective in effectively maintaining the level of competition in the market. And I'm a bit skeptical sometimes that undertakings for divestiture actually are successful in maintaining the level of competition in the market. So that's probably a worthwhile report to have a look at. Now, the other thing the ACCC did was issue a press release saying there was new evidence that backed its claim for the critical merger reform, and this was arising from a speech given by the Assistant Treasurer, Andrew Lee, where he made reference to some current research by the Treasury Competition Review Group. And they'd looked at employment shifts over a period of time and been able to work out the number of mergers occurring in the Australian market. And one of the primary findings they made was that there were in excess of 1,000 up to 1,500 mergers occurring in Australia every year, and only 330 are being notified to the ACCC. So that's music to the ACCC's ears in terms of getting their merger proposed reform proposals through, because here they're not being told about a vast number of mergers. And the first thing people say is, well, they're probably just small mergers, but as you can see there, about half of these 1,000 to 1,500 mergers were being made by the largest 1% of businesses in the Australian market. So this is large companies making significant acquisitions and not telling the ACCC about them at all. So that's a very strong argument in favour of a mandatory review process for mergers. The other thing that was interesting, this is the number of mergers by acquisition, by acquirer size. And as you can see there down the bottom is the yellow line, so that's small business, and then the blue line is large business. The black line is very large business. There's a real peak there, the beginning of COVID, and then the green line is medium business. So you can see probably half the mergers that are occurring are being carried out by large to very large businesses. So again, they're mergers that are likely to have a impact on competition in various markets, and the ACCC is not even hearing about them. Then there was one scam announcement, obviously with Valentine's Day in February, and they were warning people about various Valentine's Day scams. And as you can see, romance baiting scams resulted in 484 reports in 2023. $40 million lost through these various scams, so that's a significant amount of money. An important observation that was made by the ACCC is that these scams apparently disproportionately impact people from culturally and linguistically diverse backgrounds. And as you can see, 30% of the money lost was from people in these particular communities. So that's a concern. And the way they work is pretty straightforward. Initial contacts through a dating app or social media, but then it very quickly moves to some encrypted messaging platform, which makes it very hard to track these particular communications. So Google Hangout, WeChat, Line, or WhatsApp. And it starts off with sort of testing the water a bit and asking the victim for a small amount of money, and then escalating to very large amounts of money. The LG batteries matter has escalated as well. I've talked about this in previous presentations, and these were various electric batteries made by LG and sold in a number of different brands, which had serious product safety problems and were catching fire. And initially LG was seeking to conduct a voluntary recall, but now it seems to be heading towards a mandatory recall. So effectively the ACCC has commenced the first formal step towards a compulsory recall, and that's because there are apparently 5,000 affected LG solar batteries which have not been located. The thing I can't really understand, I do a bit of work in the solar panel industry, and I cannot understand how these batteries cannot be located, because I'm pretty sure that every particular asset used in a solar panel installation, the solar panels, the inverters, and the batteries are all tracked by the Clean Energy Regulator. So I'm just a bit puzzled as to how LG can't locate them. The inquiry's consultation, the first one, Domestic Airlines Competition in Australia report. And the good news is the ACCC found domestic airline airfares had fallen after reaching record highs in late 2022. However, cancellation delays remained higher than long-term averages. The average revenue per passenger was 13% lower, so that's a good sign. The bit of competition in the market. Average revenue per passenger in December 2023 was also below pre-pandemic levels. However, the discounts haven't come back into the market yet, so this suggests maybe the level of competition isn't going back to where it was before. And in December 2023, 5% of flights were cancelled, which is more than double the long-term average. So there seemed to be a lot of cancellation of flights. The question is, why are so many flights being cancelled? Again, there's some strong implication that this might be due to attempt to stop competitors from getting access to slots. That's the allegation. And in terms of arriving on time, only 63.6% of flights arrived on time in December 2023, compared with a long-term average of 81.1%. So again, you're just wondering, why is there such a failure to have flights arrive on time? I don't really understand. But yeah, these are quite concerning findings by the ACCC. The other thing that was announced in February was the government directed the ACCC to conduct an inquiry into the supermarket sector. And I guess we've been hearing a lot about this over the last few months, a lot of concerns. It was Alan Fels's report for the ACTU, which had some very interesting findings, and then the government finally, I guess, agreed to give the ACCC a mandate to look into the issue. They immediately released an issue paper on the 29th of February 2024, outlining the topics that they wanted to explore, and they're seeking submissions from farmers, wholesalers, retailers, and other parties. There's also a Senate inquiry at the same time, so there's quite a bit going on in this space. Now, the ACCC also established an online survey which any consumers can fill out to just explain how they go about buying groceries, how they react to price changes, how significant loyalty programs are. So anybody's really able to go online and fill that out. And the timing is interesting. They're going to issue an interim report by the end of the year and a final report by next year. So it's going to be interesting what they decide to do. I guess Professor Fels has suggested a few things that might be on the cards. He's actually talked about bringing back the sort of price exploitation laws that arose or were used during the GST period. So it'd be interesting what the ACCC recommends after they do their investigation. Now, I mentioned this last time, the designated complaints process, and this has actually now been formally introduced to Parliament by the government, and at the time of speaking has actually passed into law. So this is now become law. So this is, as I said before in the last presentation, a process where particular designated organisations can make a complaint to the ACCC and have it looked at specifically and quite quickly. So as you can see, there's a designation criteria, whether the organisations represent consumers, small business interests, and whether they can exercise their role as a designated complainant with integrity. And the ACCC has to look at these complaints and then advise publicly the complainant whether they're going to take any action within 90 days. And there's basically the types of issues that have to be raised with them have to relate to significant or systemic market issues that affect consumers, and has to obviously be a potential breach of the Act. And there's definitions there as to what a significant market issue is. So that's all laid out for the ACCC. and a systemic market issue is also explained or defined in the legislation. So it's quite prescriptive. And recently it's been decided or being proposed by the government to only approve 3 designated complainants in the first year. So the idea that there'd be hundreds of organisations designated isn't going to occur. I think probably Choice, the Australian Small Business Family Enterprise Ombudsman, there'll probably 2, maybe Crossbow number 3. So there's not going to be too many organisations designated in this space. Now, the other thing that occurred was announcement of this memorandum of understanding with the Philippine Competition Commission, and as you can see, to share best practices, conduct workshops, collaborate on projects of mutual interest. So ACCC has agreements with a lot of different competition agencies all throughout the world, and I guess the ones in some other jurisdictions, Europe and the US, are quite advanced, and there's a lot of information sharing, and they can actually give each other information about prospective anti-competitive conduct. These ones are less developed, and it really is a capacity sharing arrangement. So the ACCC is probably going to assist some of these newer competition agencies to get up to speed on investigations and some of the economic issues. So that's all I had this month. The Bingo Aussie Skips matter was a very significant matter. They're serious penalties, and I guess given that they pleaded guilty immediately, the individuals avoided going to jail, but 18 months, two periods of imprisonment and 18 months to be served concurrently are very serious, and it's just a matter of time before somebody actually does get locked up. So that was a very significant case, and I think a lot of individuals in markets are taking this very seriously. ANZ Suncorp was a disappointing result. I just don't think there's very much competition in banking in Australia, and you think that any potential competitor that could grow into something more through maybe regional mergers should be preserved, but that's not what the way the tribunal considered it. And I guess it does come down to how effective Suncorp was in the market as a competitor. It didn't seem to be setting the world on fire, so the tribunal decision is probably pretty hard to fault. The question is whether the government and the Treasurer make a different call and conclude that the merger is not in the national interest and say no to it, which would be a surprise, but is possible. The supermarket inquiry is very uncertain. I'm not too sure what's going to come out of it. I think the ACCC will probably find some conduct that's not great, but it seems to me the supermarkets are responding very quickly to at least some of the criticisms about their pricing by introducing more specials and discounts and all the rest of it. I think some of the activity might relate to home brands and the way that the supermarkets demand products from suppliers for home brands which is of the same quality as the branded products, and that's an area I think of concern for a lot of suppliers, and whether there's threats used to obtain these home brands of these high quality products. But yeah, I don't really know what's going to come out of it. It's going to be very interesting to see how it pans out. And the designated complaints is now in, and it's going to be very interesting how it pans out. The narrow number of organisations which can be designated complainants is surprising. I didn't expect it just to be 3, but it's probably best to start with a smaller number, see how it works, make sure that it doesn't get out of hand. So that's all I had. If you have any questions about this particular presentation, feel free to give us a call or drop me an email. Bye bye.